What is the significance of the questions that the judge asks the vocational witness and the answers given by the vocational witness? I'm Jonathan Ginsberg, and I'm a Social Security disability attorney. And I get a lot of questions from people who are worried about the testimony that they're hearing by the vocational witness. And if you don't know what I mean by that, is that at almost every hearing, the judge will have a vocational expert witness, someone with experience and knowledge about hiring, about placement, about everything having to do with employment in the regional or national economy. These are expert witnesses on a panel, so they appear at a lot of hearings. They're not there to help you, not there to hurt you. They're simply there to give the judge evidence about the work the availability and the work tolerances of employers in a competitive work setting. And the judges have to use vocational witnesses because they're not allowed to guess about the work implications of your medical problems. The judges can make conclusions about what the medical evidence says, but they can't say, well, this is what this means in terms of employment. So they have vocational witnesses. And what the judges do is, after taking testimony, they'll turn to the vocational witness and ask a series of hypothetical questions. And that means they're asking about a person who is, in theory, like you, but again, not exactly like you, because there are going to be multiple hypothetical questions. And some judges ask only one. That's usually a good sign, because typically that one question is going to contain some severe limitations that are going to disable you. And if the judge accepts that as the one description or profile of your limitations, you're going to probably win. Or the judge may ask 5 or 6 questions, and one of those questions will really be a reflection of what the judge is thinking. That'll form the basis of his or her decision. So you see, a judge may ask 5 or 6 questions. Some of the questions the vocational witness will say, Your Honor, here are 5 jobs a person like that could do. There are jobs at the sedentary work level, there's light jobs or medium jobs, lots of jobs. This person can go back to past work. Whereas other questions, the vocational witness will say, you know, there's really no jobs I can think of because the limitations you described are so extreme that I can't think of any competitive employer allowing a person to work at that with those limitations. So here's an example of what I mean by hypothetical question, the type of question you might hear at your hearing. And again, the judge is talking about you, but variations of you, if that makes any sense, to get a sense of where you fall in that spectrum, where you fall in that profile list. So, Mr. Vocational Witness or Ms. Vocational Witness, I'm going to give you a series of hypothetical questions. I want you to assume we have a person who's the same age as our claimant, with the same work experience and the same educational profile. I want you to further assume this person is limited to light work, and light work is defined by Social Security as standing and walking up to 6 hours out of an 8-hour day, lifting 10 pounds frequently, 20 pounds occasionally. That's what light work is in the Social Security world. I want you to assume further that our hypothetical person should avoid jobs that require him to climb ladders, ropes, or scaffolds. This person should only occasionally have to use ramps or stairs. This person should not work at unprotected heights or around hazardous equipment or dangerous machinery. This person should avoid respiratory irritants like dusts, fumes, and gases. This person should only be expected to sit for up to an hour at a time or stand for up to an hour at a time. And again, it can alternate sitting and standing, but no more than an hour at a time for each one of those. This hypothetical person should only interact with the general public, coworkers, and supervisors occasionally. By occasionally, I mean up to 1/3 of the day. And this person should avoid using fine motor manipulation, fine motor skills with the right dominant hand. That would eliminate jobs involving keyboarding or a lot of writing, extensive writing. So that's an example of a hypothetical question. And the vocational witness might say, well, based on that, our hypothetical person could not go back to being his past work as a customer service representative or as being an account executive for a manufacturing company, because there's too much fine motor manipulation, or the person would need to be sitting for more than an hour at a time. Or the past work would allow, some of the past jobs would be allowable, but other ones, because of the respiratory irritants, would not be allowed. So that's an example of a hypothetical. Then the judge may say, okay, we've identified some jobs that a person with that profile could do. Let me ask you a second hypothetical. So take everything I said about this person in hypothetical number 1, and let's add the following: that because of issues with pain, medication side effects, and other symptoms, our hypothetical person would likely miss 2 or more days of work a month, or be off task for, outside of regular breaks, off task 12% of the day. How would that affect this person's capacity to return to past work or other jobs? And a vocational expert with that profile would say, well, 10% of the day especially in an unskilled job environment, is as much limited or as much off-task behavior as would be allowed at competitive work. So the 12% would make that person unemployable. Similarly, a entry-level person could only be expected to miss 1 day of work per month. So if the person's missing 2 or more days of work a month, that is not consistent with competitive work. There are no jobs I can identify. Then the judge may ask another question and another question. Well, obviously, if the judge accepts hypothetical 2 as representing your profile, your capacity, you're going to win. If the judge hypothetical number 2. If the judge says hypothetical number 1 in his own mind is what I think your capacity is, you're probably going to lose, because there are jobs that such a person can do. So that's the way vocational witnesses, that's the way the testimony works. Just because a vocational witness said there are jobs that you could do doesn't mean you lose, especially if there are other questions where the vocational witness said there is no jobs. The problem is we don't know. And of course, I can ask questions as your attorney, but we don't know which question the judge is going to say that's representing what I think this person's vocational profile is. So because we don't know that, it's going to be very hard to predict what's going to happen. I will tell you that, having tried a lot of cases, that sometimes I can pick up on the way the judge is going by the way the question is asked, because sometimes the judge may ask one question, the first question there'll be jobs, and the next 3 or 4 questions there'll be no jobs. That's signaling to me that there's probably a favorable decision coming, because the judge asked that first question just to sort of set a baseline, and the rest of the questions basically identified why the person could not work. Judges have to justify their decisions, and so they use the vocational testimony to do that. And of course, the judge knows, for the most part, what the vocational witness is going to say. So I wouldn't fixate on one particular question the vocational witness testified to or what they said. The vocational witness is not going to make the decision, the judge is. And again, the vocational witness's function is to help the judge understand the vocational implications of your medical issues, and the judge ultimately has to make that decision. Hope you found this useful. Please give it a thumbs up on YouTube, like it on Facebook, and of course subscribe to our channels, and visit me online, ssdanswers.com. You can ask for my free Secrets to Winning Disability Survival Kit, or you can ask for a case evaluation. Happy to chat with you, and leave me a comment. Let me know what you think. Have you had experience with vocational witnesses? What was your hearing like? Do you have any questions about the vocational witness process and how that all works? Happy to hear from you, and happy to try to answer your questions that way as well. For now, this is Jonathan Ginsberg, wishing you the best. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.